Welcome back. It is time to address a new faster clock from the prosecution in the Young Thug Rico trial. Yesterday, the defense did not argue about certain evidence, text messages and stuff like that, especially one that said something of the sort of shooting back. They did that because the prosecution would have called witnesses today, jailhouse witnesses, that the defense could have cross-examined about these text messages. Now, the prosecution says, we're not going to call them. Oh, and there was a verbal fight. Let's go through it. Welcome to the show. All right, let's listen through this, because it's really interesting on what the prosecution says, what the Judge Whitaker claims to remember, and then, well, you need to watch until the end.
Yes, Your Honor.
All right. Okay, and then if so, where's the easiest place for me to find the
Your Honor,
evidence?
if I may, there's something we wanted to address first.
Okay.
Your Honor, I've got some members of the defense side here taking a look. Our understanding, and if it turns out to be wrong, it turns out to be wrong, was that the state was undecided yesterday as to whether they were going to call Mr. Bernard Mitchell. I know at the lunch break, Mr. Hiles was on the stand. His text messages had already been admitted. We went back to speak with him. The state went back and attempted to speak with him. So at that point, my understanding was it was still up in the air. I can be wrong. My understanding was it was still up in the air. Per Your Honor's request, we had discussed as many things ahead of time as possible. The discussions with the state were, and it was very clear for both sides, that we were not going to be objecting and not asking this court to litigate Mr. Mitchell's Instagram records because the state was going to call him. Yes, with them coming in, there were portions that we intended to use with the understanding that that is what would come out in terms of evidence. His messages would come out, so we would want another section in there. If the first section is in there, we would want the second section in there. But he's certainly not our witness. The evidence he presents is not a theory of the case that we would have brought to the table. And so now the state does not want to call him. And I think we're faced with a confrontation clause issue because we relied in good faith on our discussions with the state. We didn't go through and take the court's time to say this is conditionally admitted based on this happening.
Yeah, sadly, the judge has been adamant in that the state and the defense talk through as much as possible off the record. Now, we who sit here, we know that the prosecution is lying liar who lies and cheating cheater who cheats. But the defense attorneys kind of has to go by the judge's suggestions. And this is what it got them. The prosecution doing bad things again.
So we simply relied on what they represented to us. We had the evidence, came in, it was read out. I contacted the state last night to say, hey, I'm not sure what you want to do about this. We feel in a position that we are forced to ask for a mistrial. We really don't want a mistrial. We'd like to be able to rely on what we were told. And like I said, we're checking to see if there was something definitive on the record. But if Mr. Mitchell is not testifying, then we feel we have no option but to ask for a mistrial.
Would the state like to be heard on that?
I guess the state's response, Your Honor, is that the state, after the lunch hour, indicated to
Talking to the mic. Pick one up, maybe.
the state after the lunch hour indicated to the court, as well as counsel, at least for Mr. Ryan, indicating that we were not going to call Mr. Mitchell, basically because he told not only the state but defense counsel that he wasn't going to say anything when he came onto the stand. That was the same thing that was told to us by Mr. Uten. And my recollection is that it wasn't either or is what the understanding was. It was we were going to maybe call either Mr. Uten or Mr. Mitchell. And yesterday we decided neither. So I don't know how there could be a confrontation issue that's being claimed today. If we decided to put Mr. Uten up yesterday and not Mr. Mitchell, the records would have still come in.
Just listen to the garbage. For you, was there a discussion? Apparently, but not on the record. And we know that the state have a tendency to lie. So I have no issues whatsoever in saying whatever Mr. Bad Tie, whatever his name is, whatever he says, I don't trust him. Did they say this verbatim to the defense that, oh, we are definitely going to call him, and then too sad, too bad? No, insinuation, affirmation, and stuff like that is their love language. And sadly, the defense now once again trusted the prosecution for nothing. And well, sure, if you choose to, you can believe Mr. What's his face. I don't. Why? Because the district attorney's office throughout this trial have been lying over and over again.
In the same fashion without Mr. Mitchell testifying. More importantly, before any message came in as it related to Mr. Mitchell, the state indicated to defense counsel that we were not calling Mr. Mitchell. We indicated that to the court as well. And
I don't remember y'all indicating anything to the court until the end of the day, y'all. But what I was told by the deputies was that the state had very clearly said they can be transported back. We are not calling either of them. And that was at or right after the lunch hour that I was told that. I asked yesterday morning, is this an either or? And yesterday morning, the state was definitely indicated, you know, it might be one, it might be the other, it might be both. We don't know yet. We still need to talk with everybody. And then we just went on with the trial, and they didn't, you know, after lunch, they went back because y'all had made that determination, and you certainly communicated that to the deputies with regard to transport. And you are making the representation that you also let the defense know that. Do y'all disagree that the state let y'all know they didn't intend to call either witness?
Excuse me, at the very end of the day, I had inquired to the court to, you know, discuss what's going to be the order tomorrow. And I
Right.
said, well, Mr. Mitchell, Mr. Uten, checking, Mr. Kokomo took a look, and before lunch, what was represented to the court said, you know, who are we going to get to? And they said, we may not get to him today. So
That was before lunch.
that was before lunch, and then we came back in and everything was published.
And everybody I mean, not everybody, but counsel for Mr. Ryan and counsel for the state spoke with, I guess, Uten and Mitchell over the lunch break.
We went back, he didn't want to speak with us, that's fine. We went separately from the state.
Right.
We didn't discuss anything with the state about who would or wouldn't be called at the lunch. And I don't believe before we started in the afternoon. That's not my memory. The announcement before lunch was we may not reach him today. They spoke with him. Obviously, at the end of the day, I still thought they would be called.
Yeah, yesterday around lunch, there was some sort of discussion, and the question, if I recall correctly, you all can correct me if I'm wrong. Will you be calling Mr. Whatever, as in today? The answer, no. Remember, they had the jail or the prison, the sheriff's office transported these two to court today, according to information and belief, just to be returning back to prison. And why? I don't know. But whatever happened is that we don't know what was actually said between the prosecution and these witnesses. We don't know. What we do know is that they misrepresented to the defense what was going to happen. They have had these two witnesses on their witness list for weeks. This week was the time they were going to call them to testify. And then they chose not to, but not until after they got some evidence in that should have been admitted through those witnesses. This is so disingenuous.
My recollection is after lunch, I was sitting there. Ms. Abbasi said, "Y'all are, so you're not calling Mitchell?" And I said, "No, we are not calling Mitchell." That's my recollection before Mr. Howes began testifying after lunch, and we didn't.
Not calling Mitchell as today. Because yesterday you had a district attorney investigator on the stand almost the entire day, if not the entire day. He should have been there for, I believe you represented to the court after lunch, maybe an hour and a half, which was a lie.
Call Mitchell, and the messages came in unobjected or not objected to, and there's been no conditional admittance of evidence that's been
There
permitted
is not.
or agreed to by any of the parties during the trial of this case, at least the time that I've been here. So it's my indicator, be the state's opinion that any objection to the messages that came in are waived at this point.
Your Honor, our response is, we have difference of memory. That's fine. It is what it is. If the state knows they're not going to call him going into it, I don't think it's fundamentally fair for them to publish and then say, haha, you missed it. I don't think that's good faith. As far as, no, we didn't conditionally admit it because we've done everything we can, at least for Mr. Ryan, to avoid taking up the court's time. This is what it was. We all agreed. We all understood. So that's how we proceeded. And now here we are, and we're stuck in a position we don't want to be in.
Well, I'm not quite sure what to do with this. I have a representation from Mr. Abadi that the state communicated to defense counsel.
Judge Whitaker, the state, you know this because you have addressed it. The state has represented complete falsities to you to the extent that you have been barking at them. Why do you take him on his word?
Counsel that they were not intending to call Mr. Mitchell or Mr. Uten, and that was communicated prior to Mr. Hiles' afternoon testimony in which this evidence came in. And Ms. Abbasi, you're saying, well, it's not my recollection, but I could be wrong. That might be. So
I will not say my memory is perfect. I have no memory of having that conversation after lunch. I'm not going to say, Mr. Abadi's. I can't promise you my memory is 100% accurate. And I'm certainly not getting up and saying that Mr. Abadi's lying. I'm not going to do that. But I have no memory of that conversation at all. And, as I said, I brought up at the end of the day, what's the order of the witnesses? When are Mr. Mitchell and Mr. Uten coming in?
I don't remember that.
I had brought it up when we were asking about witnesses because I didn't know if the sheriff needed to bring them over. And that's what was coming up.
Are you saying that you on the record asked when Mitchell and no, you didn't?
That was at the very end of the day. We were just
Amongst counsel?
I believe Your Honor was on the bench when we were discussing just who are we getting to tomorrow.
Yeah, I asked who we were getting to tomorrow. I don't recall you saying, when are we getting to Mitchell and Uten?
Well,
I don't recall the two of them being mentioned at all at the end of the day.
This is when Judge Whitaker should have, if this was off the record, then there's no record. But we have video, don't we? Thankfully, this trial is live streamed.
I know I asked the state at that point, oh, you're not calling him? No. And at that point, the evidence had already been admitted.
I'm asking you, did you make that statement on the record?
I don't believe so.
I
We can
don't
check the
either.
record, but I don't think so. I think the last statement on the record was we may not get to them today.
I don't recall that statement on the record or off the record. This is all a surprise to me this morning that now there's some debate about it because everything I knew post-lunch yesterday, although through the sheriff's office, not through the state or the defense, was that a decision had been made and communicated that neither of them was going to be called. I can't really do much else with I don't see a basis for a mistrial. So we need to
You don't see a basis for a mistrial. Oh, you might want to reconsider that, Judge Whitaker. You might want to reconsider that. Let's listen to what did happen yesterday. Okay, folks? I will boost the sound a bit. Volume master. And let's hear what happened in the end of day 149.
who? One of
That we've
them-
already been discussing with Mr. Lee.
I was trying to find out if the state was going to be calling.
Oh, right. Okay. Okay.
Let's listen to that final part there.
Oh, right. Okay.
She says, I'm trying to find out if they are going to call these two witnesses. The judge clearly says, oh, okay. Now, let's listen to her again.
I don't recall that statement on the record or off the record.
Not only did you hear that statement, Judge Whitaker,
Oh, right. Okay.
you actually answered to that statement. I believe they should refile this motion for mistrial with this new information. Thank you for tuning in. Hit the thumbs up. Do all the things. And I see you on the next stream or video. Okay. See you. Bye-bye.